Good morning. This is your Kelso Report for Tuesday, July 10th, and I'm your host, Clark Kelso. Hope everybody had a happy and safe July 4th holiday. We begin today with the Ninth Circuit Court of Appeals, a case involving Medicare and administrative law. The Ninth Circuit's decision in Back v. Sebelius falls into the category of, oh well, never mind. As you know, the Medicare Act sets forth a federally funded health insurance program for the aged and disabled that includes hospice care designed to provide terminally ill patients with palliative care. The plaintiff brought suit alleging that the Secretary of Health and Human Services violated her duties under the Medicare Act and the Fifth Amendment by failing to provide an administrative process for beneficiaries of hospice care to appeal a hospital provider's refusal to provide a drug prescribed by their attending physician. Although the government had led the plaintiff to believe that there in fact was no appeal process, in fact, and as ultimately admitted by the Secretary after the complaint was filed, such a process does exist. Now, it managed to get up to the Ninth Circuit, but the Ninth Circuit finally dismissed the appeal as moot, a fancy way of saying, oh, never mind. Our next case also involves civil procedure, this time involving prisoner lawsuits. Now, the Ninth Circuit has previously held that in prisoner civil rights cases, when the government files a motion to dismiss, it must give the prisoner a so-called Rand notice, which explains what the plaintiff must do to defeat the motion to dismiss, named after Rand versus Rowland, the 1998 in-bank. A similar notice requirement, known as a Wyatt notice, after Wyatt versus Terhune, applies to motions for summary judgment. Well, in the Ninth Circuit's decision last week, Woods versus Carey, the district court actually gave the plaintiff these notices almost immediately after the case had been filed. Apparently, just make sure you've got those notices up front, long before any defense motions had been made. Well, the Ninth Circuit held that this extremely premature notice was insufficient, and that Rand and Wyatt notices must be served concurrently with motions to dismiss and motions for summary judgment, so that pro se prisoner plaintiffs will have fair, timely, and adequate notice of what is required of them in order to oppose those motions. As the court explained, notices served in a time when defendants have not yet filed motions to dismiss or motions for summary judgment, and may never file such motions, do not sufficiently serve that purpose. Don't want to be too early or too late, just right. Next, an immigration law case. The petitioner in Flores-Lopez versus Holder had been convicted in state court for resisting an executive officer in violation of Section 60 of the Penal Code. The BIA had used that conviction as a categorical crime of violence to conclude that he was removable under Section 237 of the Immigration and Nationality Act as an alien convicted of an aggravated felony. Well, the Ninth Circuit reversed, finding that a person could be convicted of Section 69 upon the merest contact, similar to the rule under the law of battery and torts, and that this de minimis type of contact does not rise to the level under federal law of being a crime of violence. The court remanded so the BIA could determine under the modified categorical approach whether the charging documents in the state prosecution demonstrate that violence actually was used by the petitioner in resisting an executive officer. Next, we turn to the California Supreme Court. First, in People v. Stanley, a unanimous Supreme Court held that a victim restitution order may direct the defendant to pay the victim the cost of repairing a damaged truck, even though the cost of repair substantially exceeds the market value of the truck. In this case, the cost to repair was $2,800, while the market value was around $950. Now, the usual measure of tort damages for damage to personal property is, of course, the lesser of diminution in market value and cost to repair. But California's victim restitution statute specifically authorizes an award of restitution for, quote, the replacement cost of like property or the actual cost of repairing the property when repair is possible, close quote. That's Penal Code Section 1202.4, F3, Big A. Applying the statute as written, the court held that the trial court has discretion to award cost to repair even when it exceeds market value, because such an award means the victim will have her truck back in the same condition it was before defendant vandalized it. Next we have a death penalty case, a rarity in People v. Lightsey, where the Supreme Court of California unanimously remanded the case, not an affirmance. Now, at a number of points in the pretrial and trial proceedings, questions arose concerning the defendant's mental competence to stand trial. There actually were something like 5 requests for competency hearings, and the court granted hearings on 2 of those requests. At the second hearing, the trial court permitted the defendant, who had been having serious problems with all of his attorneys, to represent himself. Well, self-representation at a competency hearing is clearly contrary to the applicable statute, Section 1368 of the Penal Code, which unequivocally provides that if the defendant is not represented by counsel, the court shall appoint counsel. So the Supreme Court remanded for the trial court to determine whether a retrospective competency hearing is feasible. Good luck doing that. And if so, for the trial court to hold such a hearing. If such a hearing is not feasible, the defendant will get a new trial. Next, we had an interesting juvenile law case from the California Supreme Court in re Ethan C., where the court unanimously held that the juvenile court can declare a parent's 2 children to be dependents of the court when the parent, by failing properly to secure his 3rd child, an 18-month-old, in a child safety seat, substantially contributed to the death of that child when the parent's car was struck by another driver. In reaching this conclusion, the court held that a declaration of dependency under Section 300F of the Welfare and Institutions Code, which provides for an initial determination of dependency when a child's parent causes the death of another child through abuse or neglect, the court held that finding can be based upon a parent's mere negligence, as opposed to being based only on criminally culpable misfeasance. The court also held there need be no additional evidence of risk to the remaining children. And finally, that normal concepts of causation apply in a Section 300F context. And the court affirmed the juvenile court's finding that in this case, the parent did substantially contribute through neglect to the death of another child in such a manner as to warrant declaring the other 2 children dependents of the court. And that's it for today's Kelso Report. Have a great day in the law.